Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. Imagine agreeing to buy a car, except the car has already been destroyed, or agreeing to buy goods from somebody who turns out not to be the person you thought they were, or entering into an agreement that the law simply refuses to recognise because it is illegal. What happens then? Can the contract be enforced? Or was there never really a contract at all? Those are the questions we explore in today's video. Now, throughout the contract law series, we've looked at things that make contracts voidable, defective, and open to challenge. Today, we're looking at something much more drastic. We're asking, was there ever a contract in the first place? Because where mistake or illegality applies, the answer may well be no. Now let's quickly look at the notion of void and voidable. And this distinction is absolutely crucial. A voidable contract exists until somebody sets it aside. A void contract is different. The law treats it as though it never existed at all. And this matters because if there was never a valid contract, there can be no breach. There can be no contractual damages, and contractual remedies disappear altogether. And that is a very serious consequence, which is why the courts only apply these doctrines in exceptional cases. Now let's begin with mistake. Students are often surprised by how limited this doctrine is. The law does not care about every mistake. People make mistakes all the time. The courts are only interested in mistakes that are so fundamental that they undermine the existence of the agreement itself. The first three types of mistake that we need for SQE purposes are as follows: common mistake, cross-purpose mistake, and unilateral mistake. Now, common mistake is where both parties make exactly the same mistake. The mistake is shared, but that alone is not enough. The mistake itself must be fundamental. So ask, does the mistake make performance impossible or radically different from what the parties intended? If not, the doctrine will usually fail. The classic example of this is imagining agreeing to buy a specific car. Unknown to both parties, the car has already been destroyed. The subject matter no longer exists. There is nothing to contract about. That kind of mistake can render the contract void. Now, what doesn't count here is that we have to consider that a mistake about quality usually will not be enough. So suppose both parties believe an item is extremely valuable. Later, it turns out to be worth much less. Now, that may be disappointing, but performance remains possible. The contract generally survives. Let's now look at cross-purpose mistake. And this occurs where the parties appear to agree, but are actually talking about different things. So each party means something different. There is no true consensus. And the important question to ask here is, can the court objectively identify what the parties actually agreed? If the answer is no, then once again, the contract may be void because contract law depends upon agreement. If it's impossible to identify what was agreed, the court has nothing to enforce. Now we come to the trickiest category, the notion of unilateral mistake, where only one party is mistaken. Most commonly, mistaken identity would come in here. And the essential question is, did the innocent party intend to contract with this person at all? Or did they merely misunderstand one of that person's attributes? And that distinction is vital. So a mistake about identity may be fundamental. A mistake about attributes usually is not. So for example, creditworthiness is merely an attribute. The law generally expects parties to take risks about attributes. Now, the courts are particularly reluctant to find mistaken identity in face-to-face dealings. Well, why? Well, because the natural assumption is you intended to deal with the person standing in front of you, even if they lied about who they were. And this is important because invalidating the contract may affect innocent third parties, and the courts are generally cautious about allowing mistake to defeat the interests of innocent purchasers. Now we need to move away from mistake entirely, and the second reason a contract may be void is illegality. The core idea here is that the courts will not assist parties who seek to rely upon illegal agreements. Put simply, the law does not enforce unlawful bargains. Now, some agreements are obviously illegal. For example, agreements to commit crimes, agreements involving fraud, agreements prohibited by statute. These agreements are generally void. So sometimes the contract itself is lawful, but the problem arises in the way it's performed. This is known as illegal performance, and it creates a different issue. So does illegal performance always void the contract? No. And this is important. The courts distinguish between incidental illegality and illegality that goes to the heart of the transaction. Let's look at an example. So suppose goods are delivered late because the driver was speeding. The speeding is unlawful, but the delivery contract itself remains perfectly valid. The driver may be punished separately, and the contract therefore survives. Now, the position becomes much more serious where both parties knowingly participate in illegal conduct. In those circumstances, the courts are much more likely to refuse enforcement altogether. Let's have a quick look at illegality in statute. Sometimes Parliament directly says that a particular type of agreement is unenforceable. Where legislation does this, the courts simply apply the statute. Now, other illegal agreements arise through common law, and the courts sometimes refuse enforcement because the agreement conflicts with public policy. The most important SQE example is covenants in restraint of trade. These clauses restrict what somebody can do after a contract ends, and examples include non-compete clauses, restrictions on soliciting customers, and restrictions on poaching employees. Now, are these always void? No, they're only presumptively unenforceable. So a restraint can be upheld if there is a legitimate business interest to protect and the restriction is reasonable. So what's a legitimate interest? Well, examples would include keeping confidential information, client relationships, goodwill, trade secrets. Simply preventing competition is not enough here. But the court has to assess what's reasonable, and the court looks at duration, geographical area, scope of activities that are prohibited. The wider the restriction, the harder it becomes to justify. So if you look at geographical area, having a clause that says that a former employee cannot set up a competing business in the same street sounds reasonable. In the same town, probably still reasonable. In the Northwest, becoming more unreasonable. In the country as a whole, definitely sounding like it would be very hard to justify. Now, whenever you see a restraint clause, ask what legitimate interest is being protected, and then, is the restriction reasonable? Those two questions solve most problems. So let's bring this all together. Mistake and illegality are exceptional doctrines. The courts do not like declaring contracts to be void. They will only do so when the circumstances genuinely justify it. And that explains why these arguments often appear as a last resort. So what's Bowdie's bottom line? Well, every mistake and illegality problem starts with one question. Was there ever a valid contract at all? If both parties made a fundamental mistake, consider common mistake. If the parties are talking about different things, consider cross-purpose mistake. If only one party is mistaken, consider unilateral mistake. And if the contract itself or its performance involves unlawful conduct, consider illegality. Most importantly, remember that voidable contracts can be set aside. Void contracts are treated as though they never existed. And that distinction is the key to this entire topic. Thanks for watching this Bowdie Shorts video. This brings to an end our contract law series. Look out for further playlists available on our YouTube channel, and thank you very much for watching.